Welcome back to SCOTUS Oral Arguments and Opinions. In this third episode of today, we'll discuss the June 18, 2025 Supreme Court opinion in the case called Oklahoma versus EPA, case number 23-1067. We'll discuss the majority opinion and Justice Gorsuch's two-sentence concurring opinion, and discuss a couple case implications. This case is a companion case to the EPA versus Calumet case. Check out my opinion summary in EPA versus Calumet Shreveport Refining, LLC for additional details. Please note that this summary is read by an automated voice. The question presented in this case is whether a final action by EPA taken pursuant to its Clean Air Act authority with respect to a single state or region may be challenged only in the D.C. Circuit because EPA published the action in the same Federal Register notice as actions affecting other states or regions, and claimed to use a consistent analysis for all states. Justice Thomas delivered the opinion of the court, in which Chief Justice Roberts and Justices Alito, Sotomayor, Kagan, Kavanaugh, Barrett, and Jackson joined. Justice Gorsuch filed an opinion concurring in the judgment in which Chief Justice Roberts joined.
Justice Thomas's majority opinion of the Clean Air Act, CAA channels challenges to Environmental Protection Agency, EPA, actions to the U.S. Court of Appeals for the D.C. Circuit if the actions are nationally applicable, and to a regional circuit if they are locally or regionally applicable. The CAA contains an exception for certain locally or regionally applicable actions based on a determination of nationwide scope or effect, which also must be brought in the D.C. Circuit. In 2015, EPA revised the National Ambient Air Quality Standards, NAAQS, for ozone to be more stringent. Each state submitted a State Implementation Plan, SIP, detailing how it would comply with the CAA's Good Neighbor provision, which requires SIPs to contain adequate provisions prohibiting in-state emissions activity that would interfere with other states' NAAQS compliance. EPA ultimately disapproved 21 states' SIPs for failure to comply with the Good Neighbor provision. These states had asserted they did not need to propose new emissions reduction measures, but EPA disagreed after considering the contents of each individual state's submission on its own merits and making individual determinations for each SIP. EPA aggregated its disapprovals into one omnibus Federal Register rule describing EPA's four-step framework for evaluating SIP submissions. EPA asserted in the rule that its disapprovals would be reviewable only in the D.C. Circuit as either nationally applicable actions or, alternatively, as locally or regionally applicable actions falling within the nationwide scope or effect exception based on EPA's use of the same nationally consistent four-step framework and its evaluation for national consistency. States and industry petitioners challenged EPA's SIP disapprovals in regional circuits. Of 5 circuits to resolve EPA's motions to dismiss or transfer, 4 found regional circuit review proper. Only the 10th Circuit disagreed, granting EPA's motion to transfer suits by Oklahoma and Utah. The 10th Circuit concluded that EPA's omnibus rule constituted a single, nationally applicable action because it covered 21 states across the country and reflected EPA's application of a uniform statutory interpretation and common analytical methods. Held, EPA's disapprovals of the Oklahoma and Utah SIPs are locally or regionally applicable actions reviewable in a regional circuit. A. Applying the framework from EPA v. Calumet Shreveport Refining, LLC, venue determination under Section 7607B1 requires a two-step inquiry. First, courts identify the relevant EPA action and ask whether it is nationally applicable or only locally or regionally applicable. If nationally applicable, challenges belong in the D.C. Circuit. If locally or regionally applicable, courts proceed to the second step to determine whether the nationwide scope or effect exception applies to override the default rule of regional circuit review. B. An action under Section 7607B1 is a particular exercise of EPA authority undertaken pursuant to a particular CAA provision. Courts determine the relevant action by reference to the CAA provision under which EPA acted not how EPA presented its decision. Each EPA SIP approval constitutes its own action. Section 7607B1 enumerates an individual SIP approval as an example of a locally or regionally applicable action, referring expressly to EPA's action in approving DOT. Any implementation plan under Section 7410. It follows that each EPA SIP disapproval is also its own action, since EPA undertakes SIP disapprovals pursuant to the same CAA authority underlying SIP approvals. Section 7410 directs each state to adopt and submit a plan for NAAQS implementation and directs EPA to either approve or disapproval it. Thus, EPA's approvals and disapprovals are opposite sides of the same coin. The two SIP disapprovals here are undisputedly locally or regionally applicable actions. A SIP is a state-specific plan, so an EPA disapproval on its face applies only to the state that proposed the SIP. An EPA decision on an individual SIP is the prototypical locally or regionally applicable action. B. EPA's and the 10th Circuit's contrary arguments fail. Section 7607B1 makes the CAA's framing of the relevant action controlling, regardless of how EPA chooses to package its decisions in the Federal Register. Although EPA was free to aggregate its SIP disapprovals into one rule, that aggregation has no significance for venue purposes. The 10th Circuit's view that EPA's action is whatever it has chosen to issue, 93F 4th at 1267, fails to grapple with what Section 7607B1 means by action, which is defined by reference to the underlying CAA provision, not EPA's stylization. The 10th Circuit also erred in deeming EPA's actions nationally applicable based on EPA's use of uniform statutory interpretation and common analytical methods. 93F 4th at 1266. The applicability of an action turns on its formal geographical scope. An action applies nationally only if, on its face, it has binding effect throughout the country. EPA's interpretive and analytical methodology goes to its underlying reasoning, which matters only at the second Section 7607B1 step. C. Because EPA's SIP disapprovals are locally or regionally applicable, the court must determine whether the nationwide scope or effect exception applies. This exception requires that 1. The action is based on a determination of nationwide scope or effect, and 2. EPA finds and publishes that such action is based on such a determination. The second requirement is satisfied because EPA included an express finding in its Federal Register notice. The court holds that EPA's SIP disapprovals were not based on any determination of nationwide scope or effect. This requirement is met only if a justification of nationwide breadth is the primary explanation for and driver of EPA's action. Such a justification does not rise to this level if EPA also relied in significant part on other intensely factual considerations, or if the key driver of EPA's action is otherwise debatable. EPA's disapprovals fall into the latter category. EPA's omnibus rule makes clear that its SIP disapprovals were based on a number of intensely factual determinations, particular to each state. Texas versus EPA 829F, 3rd 405, 421. EPA evaluated the contents of each SIP on their own merits, considering state-specific facts and information available to each state. 88 Federal Registration 9354. From this state-specific analysis, EPA produced for each state a unique list of bases for disapproval. For Oklahoma, EPA rejected its attempt to disclaim responsibility for certain emissions in Texas and faulted it for insufficient evaluation of additional emissions control opportunities. Reversed.
Justice Gorsuch's concurring opinion. The court holds that the proper venue for this litigation lies in an appropriate regional circuit, not in the D.C. Circuit. I agree. As I explain in today's companion case, however, the court and I arrive at that conclusion by different paths. See EPA v. Calumet Shreveport Refining, LLC, Gorsuch, J. Dissenting. Accordingly, I am unable to join the court's opinion, but I am pleased to concur in its judgment.
Case implications. Those were the majority and concurring opinions. Let's turn now to case implications. This decision provides important clarification about how EPA's bundling of individual actions affects venue determinations, establishing that the substantive nature of each action, rather than how EPA packages them administratively, controls where challenges must be filed. The court's application of the Calumet framework to SIP disapprovals reinforces that even when EPA uses consistent analytical methods across multiple states, the intensely factual, state-specific nature of each disapproval can prevent the nationwide scope or effect exception from applying. This may encourage EPA to be more cautious about claiming D.C. Circuit venue for actions that involve significant state-specific analysis, even when those actions are guided by uniform agency-wide policies or interpretations. The unanimous result on the ultimate venue question, despite Justice Gorsuch's continued disagreement with the majority's analytical framework, suggests the court may be finding some stability in this area of administrative law. However, the fact that 4 of 5 circuit courts reached the same conclusion as the Supreme Court, while the 10th Circuit went the other way, indicates that venue determinations under the Clean Air Act remain challenging for lower courts to navigate consistently. The decision may provide some predictability for future SIP-related litigation, but questions likely remain about how courts will apply the Calumet test to other types of EPA actions that involve both nationwide policy considerations and location-specific factual determinations. Thanks for listening to this episode. I'll be back soon with more Supreme Court analysis. If you found this valuable, please subscribe and share with anyone who wants to understand how the court really shapes our lives. Up next, Pertu vs. Richards. Talk to you soon.